Hi, everybody. Welcome. We're very happy to be here. I find Salt Lake City gorgeous. I might just move here to have me. I'm Anna Bruder. I'm a partner in the privacy and cyber practice based in Frankfurt, Germany. And my practice really covers privacy, cyber, also data developments and artificial intelligence developments. And I'm joined by Reese and Arsen. Do you want to present yourself?
Sure. Hi, everyone. My name is Reese Randall. I am an associate in London. A bit like Anna, I've got a pretty broad practice as well, focusing on IP transactions, data privacy, and cybersecurity. Awesome.
Yeah, Arsen Karinian. I'm in the Los Angeles office of Mayor Brown, and I practice data privacy and artificial intelligence.
We forgot to talk about who will control the slides. I'm sorry about that.
Hi, it's Caitlin from New York. I'm controlling the slides.
Thank you. Oh, wow. Thank you. That's amazing.
Thank you very much.
So,
All of us.
yeah, we could go to the next ones, please. This is what we will cover today. Start with the basics on the GDPR and how it can impact tech companies, especially the Utah or including Utah companies. We'll talk a little bit about recent enforcement trends, and then we'll move on to talk about the new data privacy transfer framework, the app. Sorry about that. And last but not least, we thought we would include some developments that are not strictly speaking privacy, but that also have an impact on privacy so that you're aware of what's going on. There's loads going on right now in the EU. So without further ado, Reese, would you like to tell us a little bit about the GDPR and the impact on tech companies? And next slide, please. Thank you.
Next slide, please. Thank you very much. Hi, everyone. It's a real pleasure to be here. So I think just very quickly, I want to set the scene on what the GDPR legal framework actually is. So I know many in the room and online will be familiar with GDPR. So that is the primary legislation that governs the processing of personal data in Europe. It kind of has a sister law, if you like, which is the UK GDPR. And that is just a carbon copy clone of the EU GDPR as it applies in the UK. Following Brexit. I think what the GDPR and both GDPRs really are trying to achieve is to offer individuals a greater deal of control in how they understand how their data is being processed, but also to give obligations onto companies to provide a recourse measure and also be transparent in how that process can take place. I think a couple of characteristics of the legislation just worth mentioning to help underpin that is firstly personal data, or the definition of personal data. So it is any living individual, any personal data, or any information relating to a living individual can be personal data. So that isn't just direct information on your name or your address, but it could be indirect information such as an IP address. Also, the definition of processing is incredibly broad. It includes not just transferring the data or actually compiling it or doing something with the data. It also involves simply viewing that data. So you could be based in Utah and the data itself could be housed on a server in Frankfurt. So simply opening that up on a device here in Utah is still a processing activity. So just on the bottom of the slide there, we've got fines. And this was really something that made people sit up and take note back in 2018 when this law was passed. Euro 20 million or 17.5 million pound fine, per fine, say, or 4% of the annual global turnover. It's pretty substantial. And that is something that we'll come to a bit later on when we talk about enforcement trends. Next slide, please. Thank you. And here, I won't go through each of these principles, but effectively, the GDPR is a principles-based piece of legislation. You've got these 6 principles, which kind of underline the foundation of the law. And really what you need to be thinking of is, do I have a purpose for the processing? Do I make sure I only process personal data that's limited to that purpose? Do I not store the data for longer than it's needed? Am I keeping accurate records of the data? Have I got appropriate security measures in place to protect the data? And do I have a legal basis to process that data? Next slide, please. So here we just wanted to quickly introduce how Utah tech companies can be impacted by the GDPR. And the first is direct applicability. So, data privacy really is a global tool you need to be thinking about, and the GDPR does have extraterritorial effect. And there are three real mechanisms through which you could be directly under the GDPR's remit if you're based in Utah. And the first is if you have an establishment in the EEA or in the UK. So that could be an EU-UK subsidiary, but it also could simply be an office or a branch that's controlled from Utah, but is present in the UK or Europe. And all of the processing activities of that branch would need to comply with the GDPR. Secondly, if you are monitoring the behaviour of individuals as they take place in Europe or the UK, that also would be something bringing in direct scope. And that could be such as location tracking. You know, an app based in Utah that offers a location tracking service or has a functionality for tracking location of individuals in the UK or Europe, and that could be a monitoring activity. And then thirdly, offering goods and services to individuals, and that's important to individuals in Europe and the UK. And there what you're thinking about is when you offer your good and service, do you offer that service in the local currency of euros or pounds, or do you have a service rep that's based there that can take phone calls, follow the sun type business model? Or, also, do you offer shipping? Do you offer the option for the services of the goods to be shipped out to the UK or to Europe? And if you're doing any of this, the processing activities that are attached to the establishment or the monitoring or the offering of goods and services fully needs to comply with the GDPR. So you need privacy policies, you need to have data breach response mechanisms in place, you need to have a GDPR level of security. So it can be a pretty substantial undertaking. Next slide, please. And, besides direct applicability, and this is probably where, Utah-based tech companies might encounter the GDPR more, you do have indirect applicability. So this is where you're based in the US, you contract with a supplier or a service provider, some other vendor in the UK or the EU. Then all of a sudden you look at your contract and it's full of GDPR provisions. This is an indirect way in which you're subject to the GDPR. I mean, this doesn't mean that you fall within scope of the GDPR or that you can be fined under the GDPR simply because contractually you've got these obligations. They are contractual, but it's important to just be aware that these EU and UK based third parties will themselves be subject to GDPR and try and put these measures into your data processing agreement. And then Arsene, perhaps you could share any tips and tricks when it comes to negotiating these DPAs?
Yeah, I think the thing with DPAs are, unlike general commercial terms where it's largely negotiable as to whether you want this provision or not, the DPA itself fundamentally, it's a creature of law. There's legal requirements on what terms need to be in the DPA. That's the case actually under EU, UK GDPR, as well as US privacy laws. So sometimes when I'm negotiating a deal, somebody will just outright delete a provision saying, I don't like this, or I don't want this in there. I'm like, well, too bad. The law requires it. Where, however, there are some negotiation points is sort of how broad or narrow you want some of the provisions to apply. So for example, one of the things required under both GDPR and the US privacy laws is to require an audit be done of the vendor, processor, service provider, whatever terminology you want to use under these various privacy laws. If you're a service provider, usually service providers try to make it more vendor friendly. And so they'll say, we'll provide you a report once every 12 months that documents, our compliance protocol, or there might be a negotiation to have a third-party auditor involved instead of the controller auditing your practices. So those are some of the push-pull scenarios that could happen. And then some of the other negotiation points are the limitation of liability provision, which is oftentimes in the master agreement, but the vendor, the processor wants a cap that is maybe 12 months of fees paid, while the controller will want unlimited cap. And so often the compromise we reach on is somewhere between 3 to 5, which is very favorable to controller, or somewhere below 1 million, which is favorable to the processor.
And maybe I'll chime in there just to say, in my experience, the different customers in Europe can be more or less picky and more or less open to what you're telling them. So I've seen some that really don't care, just take a template DPA, they'll sign it, and some that we want to negotiate every single detail. Also the audit clause that Arsen just mentioned, some really want to be able to get in there and look themselves, some not. So really, I think if you are a tech company, you should have a DPA, of course, that is friendly for you, and just have some fallback clauses in case you have to track.
Thank you. Next slide, please. So I think, we spoke a little bit there about direct applicability, indirect applicability, but there is just another component of the GDPR that we thought we'd like to highlight, which is the data processing roles. So a key component is that distinction between whether you are what's called a controller or a processor. Controllers really are the entities that decide we're going to start processing data, this is what we're going to collect, this is why, and this is how we're going to do it. So they really have a lot more obligations than processors. And then a good example may be a company will be a controller for its HR data. It decides who it employs, what it collects on that individual, and the process and any onward processing. On the other hand, you've got processors. These are processing data on behalf of the controller. So I think, for this audience, a good example would be a SaaS provider. The SaaS provider is processing the personal data in a tech capacity for its customer. And yeah, it's important, to understand that distinction because, as I mentioned, controllers are subject to some more obligations, but from a contractual perspective, controllers and processors need to have certain agreement in place, which includes certain Article 28 provisions. So as Arsen mentioned, there are some mandated provisions that you should expect to receive. Say if you're a SaaS provider in Utah as a processor, you should expect your controller to be providing or requesting certain clauses in that regard. So I think if we could just move over to the next slide, and I'll pass it to Anna. Perhaps you can tell us a bit more about the enforcement trends that we've been seeing.
Yeah, sure. So next slide, please. What we can see here is that the level of fines has been increasing exponentially. We are now at 4 billion, that's at 4 billion euro cumulated fines in the last 5 years. Next slide, please. You will see here that the top 10 fines were all issued against tech companies, be it US tech companies or European subsidiaries of US tech companies, right? And half these decisions that you see here were about the use of cookies, which if you're a tech company, if you're a SaaS provider, you don't have any control of potentially, but the other half is really about other topics, about data processing, legal basis, those principles that we talked about. So this is really a very relevant topic specifically for tech companies. Next slide, please. On this slide, I just wanted to show you that you are number one target, unfortunately, but there are many other industries that are also concerned, so don't feel offended. And on the next slide, I wanted to focus a little bit more on the hot topic data transfers. I will try to tell a story in 4 chapters to make this more interesting, much more interesting than it really was to go through all that. Chapter 1 is Schrems 2. So the Court of Justice says you can no longer rely on the privacy shield, which was an agreement basically between the EU and the US for the free flow of data. And the Court of Justice did say you can continue to use SCC, standard contractual clause. Chapter 2, there were some developments there, new SCCs, and some guidance from the European Data Protection Board about the use of these new SCCs. The big hot topic for you guys is what the DPP said is based on Schrems 2. You need 2 things to rely on SCCs, in accordance to their guidance. You need the transfer impact assessment, which is basically a document that analyzes US law, analyzes US practices, and the data that you're transferring, how you were protecting it. Basically, on the bottom, you're supposed to say, we're good. The measures that we have taken are sufficient to protect data. And number 2, you need supplementary measures. Now, that's a real pickle. I've had a number of deals where it's just not implementable. What are we talking about? Pseudonymization of personal data, which means, imagine you're a SaaS provider and your customer is inputting all this data, their data, right? Their customers' data into the data set. There will be names there. There will be addresses. I don't know what else, depending on the tool, depending on what your customer is putting in there. You don't have any control over it, right? but this is all personal data if it's individuals in the EU. Pseudonymization means removing all identifiers from the data set. So for example, I've seen that in one deal I had, the agreement was because it was a very picky German client, let's just take the fields that are names and addresses and remove those or encrypt those. So it is doable in some cases, but very difficult. Pseudonymization, the second I just mentioned, is encryption, but importantly, the key needs to stay in Europe under control of the party that is exporting the data. So for example, I just mentioned pseudonymization, the correlation between an individual and the code that you're using to refer to this person needs to stay in Europe, and encryption as well. So the key needs to be in Europe. Doesn't mean that the provider can't have the key, but the exporter in Europe needs to have control and needs to be able to change it frequently, needs to manage it. The key management needs to stay there. So really very difficult to implement. Chapter 3, it's imagine a dog that barks a lot but doesn't bite. That was the DPAs at this point in time. There were some decisions that I noted here against European companies with regard to the use of these tools, right? You may have heard the Google Analytics decisions, the MailChimp and Cloudflare decisions. It's basically DPAs all over Europe saying, hey, this doesn't look too good. It doesn't look like these tools are using supplementary measures like pseudonymization encryption, so please stop, but no fines. So everybody was pretty chilled at this point, because if I'm just gonna have to stop using the tool, okay, it's not great, but it's not the end of the world, right? Now, chapter 4, which I didn't put on the slide because it was 2 slides ago, the Meta decision that came in May. That's the highest fine ever issued, 1.2 billion euro. Yeah, that's it. Specifically because no supplementary measures had been implemented by Meta. So, now it's a dog that bites as well as barks. It does increase a tiny bit at least the risk level for you guys. So, sorry, go ahead.
When you're talking about pseudonymization,
It's the hard one.
how much do they worry about re-identification?
So if the pseudonymization key is in Europe with the data exporter, they don't worry that much.
But sometimes you have, 3 dozen fields and you can re-identify based on the remaining.
Oh, then
Is that a big concern?
that's a concern, yeah. Then that would mean you don't really have pseudonymization in that.
Right.
The real
Not effective.
pseudonymization is you cannot correlate.
Yeah, but it's not as easy as just dropping out names and addresses.
You're absolutely right, yeah.
No, it could also be like IP addresses and then also, you can maintain a lookup table. Like, let's say the code you assign to the name address is ABC123. In Europe, you can have a lookup table that says ABC123 is Mark. But the moment the table and the pseudonymized data merge together, then it's no longer pseudonymized.
Exactly.
Next slide. Thank you. So Anna's set the scene very well there. It's incredibly complicated and the dog is definitely starting to bite. But really, and many in the room and online may be familiar with this, there are restrictions from a data transfer perspective when it comes to taking data from Europe or the UK, transferring it outwards. The de facto position is that if you have an adequacy jurisdiction that has an adequacy decision, which is where either the European Commission or the UK government have deemed the level of protection for data privacy you provide in your country is adequate, then the data can flow freely. If there is no adequacy decision, then you need to look at one of these safeguards in the GDPR. And the most common is the standard contractual clauses, plus the transfer impact assessment. And these are just clauses that have been approved by the European Commission and the UK government to allow that free flow of data. If we could just move to the next slide, please. So, there is this new EUUS data privacy framework. You haven't seen this, it's been everywhere, but effectively on the 10th of July this year, the European Commission adopted an adequacy decision for US entities who have self-certified under the EUUS DPF. And this is the latest in a long line of agreements between the 2 regions on transatlantic data flows, and it follows Privacy Shield, which was struck down in 2020. And this new mechanism, if you just go to the next slide, please. has been labelled as Privacy Shield 2.0 really, because not much has changed. I think one thing to note is that no certification equals no change. So this is an adequacy decision for entities that have self-certified under this regime. It's not a blanket adequacy decision that the US is adequate and that transfers can be undertaken freely. Instead, what you need to do is to self-certify and basically say that you apply at that time of certification with the DPF's principles. These cover things such as GDPR-like notice requirements, accountability for onward transfer, also some GDPR-like security measures. I think, Arsene, it'd be really beneficial just to get a US perspective for a US entity on what it looks like actually to certify under this regime.
Yeah, I think in theory, it's a great idea to utilize the EUUS data privacy framework, but at least at the moment, there's some drawbacks to it. For starters, it only covers EU to US transfers at the moment. There is a Swiss US and UK US framework as well, but it hasn't been validated yet. So in other words, you can't send UK data in reliance on this or Swiss data in reliance on this, at least yet. It's probably soon going to pass. But the biggest drawback is Max Schrems, who's the privacy advocate in Europe, who's been challenging the transfer of data to the US. He already said he's going to challenge this one. And so it's to be determined whether we're going to have a Schrems 3 decision that's going to invalidate this framework.
Oh, and if I can chime in, there was already an action that was filed by a member of the European Parliament from France contesting this decision, the adequacy decision. And there will be many in the months to come, right? So it will be a bit of a test whether they will pass or not. Sorry, back to you.
Yeah, so basically, let's say you're entering into a number of contracts with processors and vendors, and you negotiate these contracts for 2 years, and you relied on this framework, and you didn't include the standard contractual clause, which are these EU-approved clauses you just slap onto the end of a contract, then you're going to have to go back and renegotiate all those contracts, or at least add on the new standard contractual clauses until we know that it is going to remain valid. But should it change, should it become valid, and the Schrems 3 decision says you're all good, go ahead and transfer, then it's a great mechanism. But as Reese mentioned, if you register, you have to be prepared to comply with those principles up there. And there's some pretty detailed guidelines within the data privacy framework, because if you don't, then you're engaging in an unfair and deceptive practice act with the Federal Trade Commission. And so your company name is going to be on the list that they're going to look at. So you better be sure you can adhere to that. Although I should say, if you can't adhere to that, then you sign standard contractual clauses, and that could be a problem too.
Yeah, it's really, sorry, but you're a bit between a rock and a hard place. Because if you have this, you are submitting yourself to the jurisdiction of the FTC.
Yeah.
If you don't have this and you have the SECs, but you don't have the supplementary measures, theoretically, there could be enforcement against you too, right? So so that's one thing. The other thing is the practicality of it all. Like if you have, for example, if you're a SaaS provider and you have a number of European customers, this might be a good opportunity for you, the DPF, because then you don't need to sign standard contractual clauses with I don't know how many customers you have, right? So from a practical perspective, it must be much easier than the SECs. Anything else to add on the pros and cons?
So Anna, can I just push on that a little bit? So I'm trying to understand, Arsene made it sound like almost you don't want to do this, right? Because
At least for now.
Because of puts a target on your back, and because the chance it's going to get overturned, so you're going to go back later and paper. And so I'm want to push a little bit. Why would somebody do it? You're saying it's because it's easier. You don't have to do the standard contractual clauses. That may not be persuasive to somebody who's used to doing the standard contractual clauses. Are there other reasons to go ahead and certify besides that?
Yeah, can I go first?
Yeah, go ahead, Anna.
So one thing I'd say, the SECs come with transfer impact assessment and supplementary measures. Some of the pickiest European customers, they will not be happy with SECs only, or SECs and transfer impact assessment. There are some that will say, no, if you don't implement pseudonymization encryption, I won't work with you. I've seen that, unfortunately, a number of times. So for those, if you use the DPF, you don't have to have pseudonymization and encryption. Data can flow freely without those measures, even though the DPP says it's recommendable, but it's not a rule, it's not a requirement, right? So I'd say that's the number one case where somebody might decide to go with the DPF in spite of those negative aspects. What do you think?
Yeah, I mean, the standard contractual clauses, they have their own risks to them. So if you're very European focused and you're scared of that 4% global turnover fine, the relying on the SECs is actually pretty risky. Because the way the Schrems 2 decision ended, it essentially said, yes, you can rely on SECs, but we find that the US surveillance agencies are harvesting all your data, they don't adequately protect EU residents, and it almost sounded like they automatically concluded that the US is not an adequate country, and that no matter what you do, it's not going to be good enough because the NSA and the CIA are collecting data through the transatlantic cable. And so a lot of these, I think right after Schrems 2, the German, there's various German DPAs that came out and says you can't send data. So it remains risky to rely on SECs, as we saw with also Facebook's $1.3 billion penalty. So that remains on risky grounds. And, you know, it's questionable whether Federal Trade Commission will actually go after you. I mean, there's a number of companies registered, and it's a very small department at the FTC. So who knows if they'll sit down and target every single one of them. So you might slip under the radar, but not slip under the radar in Europe.
Pros and cons to each other. The thing that I'm hearing is really similar to Hannah's. What some of my clients are saying is because of the marketing, because we can say to our customers, we are compliant with data privacy framework. We're a step ahead of maybe some of our competitors who aren't. And so to them, it's becoming a marketing decision really to do it.
Yeah.
Absolutely true.
Yeah, and everybody likes to hear that marketing buzzword of GDPR compliant, even though it's nonsensical, or, you know,
They're using it that
privacy
way.
framework.
They're using it that way, but
Yeah.
it's interesting.
But I have a deal right now. It's a clinical trial in Europe for a medical devices manufacturer in the US, and that really saved the deal. Because the sites in Europe wouldn't sign SECs, and then the authority didn't had a problem with it, and then the platform that is doing the processing the data, transferring it over, said, oh, we got it, the DPF, here you go, really saved the day. So there are cases where that can be really a solution. All right, I guess we're back to you, Reese, to talk about the concluded data transfer bit.
Yeah, sure. So if we just go to the next slide. So this is the first of two kind of flowcharts that really is meant to be taken away as a takeaway item. It just goes through a decision tree essentially based on what you're doing and whether you'll need to put SECs or a DPF in place, or whether you're undertaking a restricted transfer. So this is really visual for your takeaway after the session. If you can just go to the next slide. Thank you. And, you know, Arsen touched on this. Effectively, the DPF is just for EU to US transfers. At the moment, the UK and the US have committed in principle to a deal, which is effectively an extension of the EU-US DPF. And as it says on the slide, it's just a matter of time before this gets signed. So there's a lot in the UK that's going on at the moment that I think politically are trying to align, but this is definitely on the agenda. Next slide, please. And again, if your UK data is involved, here is a flowchart that you can consider to assist you with that. And I think next, Anna, perhaps you could share some thoughts on new EU and UK data privacy tech-related developments, which are not actually in the GDPR ballpark.
Sure, I'm happy to. Can we go over 2 slides ahead, please? So we have a few new, actually we have 7 different pieces of legislation in the EU. I picked 4 here. I'd say there are 2 buckets here. One is digital regulation. The second is data regulation. We keep it very high level, but if you have any questions, we're more than happy to go into more detail. The first bucket, the digital regulation, there are 2 pieces of legislation, the DSA and the DMA. You may have heard of them because they're also all over the place right now. So the DSA is the Digital Services Act. It's really about the provision of digital services. So if you are an intermediary service provider, something like domain name systems, or if you are a web hosting or a cloud provider, that would include SaaS providers that have cloud functionalities that they offer their customers, they would definitely be in this bucket. Or if you're an online marketplace, selling basically goods, like eBay, for example, or very large online platforms or very large search engines. Those are called VLOPs and VLSs, that's how I call them, the abbreviation. They were just designated by the European Commission. You may have seen that going by. But I think probably potentially what's more relevant for this group are those other categories, the cloud provision and the SaaS providers. So if you haven't yet, it would be good to take a closer look whether you are in scope of the DSA. If you are, there may be some obligations that apply to you starting in February. And it's really about content moderation. It's about creating mechanisms for people to be able to tell you, oh, this is illegal content, and then you have to remove it. So specifically for cloud providers, for example, you will need to create a mechanism to receive notification of illegal content. And that surprised me quite a bit. You will need to go to law enforcement with this information. So you're going to need a process for that, clearly. Also, if you're in the US only, you don't have presence in the EU, you will need a representative in the EU under the DSA. So that's it for the DSA at a very high level. The DMA is very focused on competition in the digital markets, and it really applies to gatekeepers. Gatekeepers are these really large providers of core platform services. They were named designated just last week by the European Commission. There are 6. I can tell you their names. It's public information. Alphabet, Amazon, Apple, ByteDance, Meta, and Microsoft are the ones that were designated gatekeepers. They have loads of new obligations falling on them, and it goes from e-commerce obligations, how they treat their business users, how they treat their end users, over to data. For example, there's one here that's very relevant for marketing, for targeted advertising. Right now, before it starts applying in March, what these gatekeepers do is they have so many services that they offer, like Google, for example, and they can just combine all the data from all these services. They won't be able to do that anymore without consent of those individuals whose data we're talking about. So you see, it's very strict, very related to privacy, even though this is not strictly a privacy piece of legislation. And I think what it could impact you is that if you are dealing with gatekeepers, these new obligations of gatekeepers can mean rights to you, depending on what you're doing in your relationships with them. So as I said, as of March next year. And then the second bucket is the data developments. The DGA, the Data Governance Act, is the least interesting from all 4. So it's really just about public sector sharing data if they want to voluntarily. The last one, however, the Data Act, that has the potential to be a mini revolution because it's non-private personal data, so any data basically, and it's very focused on connected devices, which is more and more the case, right? So the key really takeaway, there could be data sharing obligations in the context of those connected devices. This is in draft form. There's a lot of political will to adopt the Data Act still this year, but there's quite some fight within the European institutions as to how do you protect trade secrets? How do you protect other IP if I'm forced to share my data, right? So let's see what that comes to be. Next slide, please. I do want to talk about my favorite topic, artificial intelligence. You may have heard the EUAI Act as a buzzword in the last few months. The EUAI Act, which is now also in draft form, is really about regulating artificial intelligence in the EU, and that will apply, let me start with this, when it will apply to you potentially. That is if you are providing AI tools in Europe, in the EU, or if you're providing AI tools that can be used in Europe. So if you're a provider, of course you don't know where your tool is going to be used, right? But if you're targeting the EU market, you're very likely to be under scope. It's a risk-based approach. So you have these 3 risk categories. Prohibited is, for example, social scoring. High risk, I will tell you some examples about that. And the limited risk, for example, chatbots. So for the lowest level, all you need to do is be transparent. Basically, the individuals need to know that they're talking to a chatbot, for example. The fines are very high, up to 40 million. And as I mentioned, this is not adopted yet, but it will very likely be adopted very soon. Next slide, please. I just put in there some examples of high-risk AI systems. For example, medical devices is there anything relating to biometric identification? So if you're using, fingerprints to identify to get into a building, if you're offering any AI tools with regard to that, employment context, you may have seen there are actually many tools that you can use now for recruitment, basically filtering of AI. Just put loads of CVs in there, and you can say these are the criteria, and it will help you with the recruitment. There is already litigation in the US about that because of potential discrimination, right? I think the example that I have, you can help me with that, Arsen, was a case where 80% of the suggestions were middle-aged white males, and colored people and females and disabled people had no chance at all with the algorithmics. So this is where the AI Act is coming from. If you have a high-risk AI system, what does that mean? Next slide, please. I just put on the slide.
Is that a training bias in the AI?
Yeah, the requirement, right? Exactly. So you see, this slide is exactly the key obligations under the EU AI Act. Under data governance, for example, is the requirement to make sure that you are training your model with data that is accurate, adequate, appropriate, right? Under testing, so each of these boxes there is like a whole chapter under the EU AI Act, right? But under testing is, for example, making sure that the output is not biased. And of course, that has a relationship with the data, right? Depends on the data that you use to train your model. Transparency and oversight, that's the discussion we were having yesterday. It's really about making sure that AI is not going to take over the world, right? We humans want to keep control. So every AI system under the EU AI Act that is high risk will need to be subject to transparency and oversight, and human oversight. And that's also the case of other proposed frameworks in the world. Then cybersecurity, record keeping, some risk management, some quality management. One thing I want to add here, didn't put in the slide, but I think it's an interesting info for you. How do you split the responsibilities, the obligations, right? If you're a provider of an AI system, of course, you have no idea what data your customer is going to input into the system, how they're going to use the AI tool exactly. Same thing with transparency and oversight. The provider could develop the tool in a way that allows for transparency and oversight, but whether the deployer is really going to make sure that this is in place, you have no control, right? So this is, there are some provisions in the draft EU AI Act about that, how to allocate these responsibilities, but a huge part of it will be the contract, right? So lots to come on contracts on liability, for example, for regulatory requirements of AI systems. Okay, and then next slide, Reese, do you want to tell us a bit about the UK and AI? I think it's a shorter story.
Yeah, so fortunately, not lots to tell you. Time being, the UK has decided that instead of actually legislating for AI, instead we're going to have a white paper that was announced earlier this year, which sets out those 5 principles on the slide. So safety, security, robustness, appropriate transparency, fairness, accountability, and governance, and contestability and redress. So the headline, no new law in the UK for AI regulation. Instead, what the UK is really seeking to do is just to lean on existing regulators in certain industries to manage the effects of AI in their remit. So the Information Commissioner for Data Protection, the Financial Conduct Authority in the financial services industry, and the CMA, the Competitions Market Authority for Anti-Competitive Practices. If we could just go to the next slide, please. But that being said, I think, politically, the UK still wants to be seen as a leader when it comes to AI, and the UK is going to be hosting the first global AI regulation summit this November at Bletchley Park in Milton Keynes, and that's going to be a summit that's going to be attended by political figures, industry experts, and also academic experts on AI. So although the UK is not legislating, it still sees itself as being squarely in the discussion, and I think this is a space that we'll definitely be watching. So think that concludes our presentation. On the next slide.
Sorry, I wanted to
sure.
chime in just one more thing on AI. I just wanted to do a little bit of publicity, if I may. We have an exciting global multidisciplinary team that is working on AI, and we already have a few very, very interesting projects. From our perspective, from the European side, some clients that are taking early compliance steps because they are developing AI tools. So they figured I might as well take into consideration what might come before I finish developing, and then I'll have to come back and review everything. Working very closely together also with Arsen on the privacy front. We have some documents that we prepared for clients, for example, AI impact assessments, data protection impact assessments in connection with AI tools, and much more. So if you're interested, more than happy to talk more about that. But I agree with you, and that concludes our presentation. So if you have any questions, we're more than happy to take them. Sorry to have interrupted you there. That's just got too many questions.
And so most of these, I guess, is for Arsen. Let's say you're a Utah tech company. You hear this presentation, you've heard about GDPR, you hear about California laws, you hear about Connecticut, Utah, you've got laws in Brazil, you've got laws coming in China, you've got a maze of regulations. How do you get your arms around it? What do you do if you're, what do you do to start? What's the?
Well, the hard part is, or the way not to do it is just to play whack-a-mole. I mean, it's largely driven by whether you're centralized management or decentralized. So if you are a decentralized organization, which tends to be the minority view as far as managing a business, but if you are decentralized, you could technically rely on the different geographic areas that will implement compliance on a local level and report up. And then there might be some top to bottom guidance from top to bottom coming down on you need to comply with privacy laws in your region. But most organizations are managed centralized, so it's top to bottom. And in that scenario, I think it's helpful to have a harmonized plan. A lot of these privacy laws internationally, there's over 150 of them. Their key elements can be boiled down to common principles, common requirements, whether you're drafting a data processing agreement, whether you're drafting a privacy policy, they share a lot of common elements to them. And so what you need to do is you need to start off with what I like to do is a 6-phase approach. Phase 1 being implement privacy leadership in your organization. You know, not every organization has a chief privacy officer or somebody who's a privacy guru, but you need a person or persons in the organization that are going to take ownership of least of privacy. And then you document a policy that reflects their the duties and responsibilities of the privacy leader or leaders or by committee. And then they give the direction from top to bottom. Phase 2 requires doing a data inventory or data mapping. You can't implement the privacy compliance program until you know throughout your organization what you're collecting, why you're collecting it, who you're sharing it with, where is this data going. And frankly, that phase 2 process, I feel like is very enlightening for a lot of companies.
It's probably easier said than done. A lot of people say, oh, of course I know, but then you get into it and you realize, wait a minute, there's a lot going on here.
Yeah, I mean, you have different stakeholders in the company, somebody from procurement, somebody from marketing. And for the first time, they're finding out that different people are doing different things. And sometimes it sparks a conversation. So it's actually a good business opportunity to get the company sort of in alignment. But once you get that insight, then you move on to phase 3, which is a gap analysis. And what you do is you identify first which laws apply to us. And so you identify the laws, what are the legal requirements. You might actually be doing a lot of the things needed to comply, but you want to identify the delta of what you are not doing. And then to close that gap and implement the compliance solution to fix that. Phase 4 is impact assessments. So certain processing activities are very high risk. If you collect information about somebody's social security number, race, gender, ethnicity, et cetera, there's certain risk areas like health data, biometric data. If you collect that type of data, you want to do an impact assessment that says, here are the risks, here are the mitigation measures, on balance, we're okay with moving forward. And if you document that and a regulator comes to you, you can explain why you're engaged in this risky processing activity. And then the final step is phase 5. Phase 5 is a lot of the stuff you probably have already done, like drafting a privacy policy, internal policies and procedures on how to comply with the laws. And when I do a phase 5 program, I like to identify all the laws that are applicable and then just draft it in a harmonized way. For some companies though, if they're just subject to California's privacy law and that's their universe, great, we'll just draft the California privacy law compliant program. Or if you're in Utah and you're just subject to Utah's privacy law that goes into effect end of the year, maybe that's the approach you take. But like most companies, you have a footprint everywhere. And so you want to sort of, cast a wide net and implement compliance. And then finally, phase 6 is just having a 1 or 2 page auditable record. It just summarizes everything you've done. And so if you're audited, you can just turn that over to the regulator and say, here's everything we've done. And sometimes they'll go away. If they want to dig in further, then you have a whole 1 through 6 compliance program already set up. Now, when I say phases 1 through 6, it's not the exclusive means, of course. I've seen some people break up that 6 phases into 12 phases and 15 phases into 3. It just depends on how you sort of organize it, like the accordion, back and forth. But really, the 6 phases just sort of covers everything fundamentally that you would do.
Related to that, suppose I like to make wooden toys for children in my garage and sell them over the internet. Or I don't even sell the toys. I sell plans for how to make wooden toys. I'm a one-man shop, have very low revenues, but people who want to buy things have to give me their name and email address, put in a password to create an account.
Yeah.
And it's on a website, so somebody anywhere in the world that can get access to the internet can come sign up.
Yeah.
How does my tiny little business get affected by this?
Yeah, I mean, a couple of issues come
How
into
do I comply?
Yeah, well, I mean, a couple of issues come into play. I think if you start with jurisdictionally, obviously, if you have a website, it could be accessed anywhere. So the question is, just because my website can be accessed in Thailand or China or Europe, does that automatically mean that I'm subject to their privacy laws? And the answer is no. You could be if you direct certain activity to a jurisdiction, and that's the case for most of the 150 plus privacy laws. If you direct your products and services. So for example, if you had that toy company, you set up a website and you advertise the toys in Euro currency, you said you advertised it in Deutsch or Parlez-vous Français and whatever language you did it as EU languages, then you're clearly directing the activity to EU residents. Or if in Mandarin, then you're directing it to China. So those are some of the factors that are considered. But if you're just a local shop and your website is directed to a US audience, or maybe even just locally here in the Salt Lake community, odds are you're likely not going to trigger a lot of the other privacy laws. Like California's, for example, to trigger it, one of the ways is annual gross revenue of $25 billion or more. So God willing, you make that and you trigger that, and then you can pay your attorney's fees. But if you're a small time shop operating in your garage, you're probably not going to trigger that. A lot of the other standards that trigger some of the US privacy laws deal with the volume of data collection. So you got to collect 100,000 persons' information in Colorado or Connecticut and some of the other states like Virginia. But if you don't meet that volume level and you're like a really small shop, you're likely not going to trigger it. But that said, you do want to practice good data privacy hygiene. Have a secure website, maybe a cloud storage system that's encrypted. You don't want a data breach to happen. And you could also rely on reputable like payment processors so that you're not dealing with credit card information, which is a whole different.
You don't want to build that stuff from scratch. Right?
Exactly.
Sign up.
AWS Cloud, Microsoft Azure, and you use one of the many payment processors out there that are PCI DSS compliant. That should cover that.
So I'll go on selling plans on how to build wooden toys.
Yeah, by all means, in time for Christmas.
So kind of a related question is, you show the graph of the ballooning fines in EU, but that top 10 list or whatever looked like the big players, right? To what extent is enforcement being directed to the small size, SaaS companies from the US that have some incidental collection of European data, or is that still totally under the radar at this point?
So I think very much under the radar, right? That's why up to the Meta decision, I'd say very, very low enforcement risk. Now with the Meta decision, the risk is that because the Court of Justice with this 1.2 billion fine is really telling the DPAs, this is important, don't forget this topic. Because this is what was happening. I have somebody in my team in Frankfurt that used to work for the Data Protection Authority, and she told us that whenever a German citizen was making a complaint because some company was using Google Analytics, for instance, they would just forward it directly. Because what can you do? Everybody understood it's complicated. There are no alternatives actually in Europe. So that was the situation. And now with the Meta decision, it's kind of like the Court of Justice saying, don't let this die off. This is important. So I don't know what's going to happen, but you're totally right. I completely agree that the focus of the DPAs in general, and I see this also in the context of breaches, the DPAs are going for the big fish. They're not really worried about the smaller players because they want to be impactful, right? And that's the way that's their strategy, basically.
So in the real world, my sense is that a lot of Utah or US companies, the impact they feel is going to be contractual requirements that directly or indirectly filter down to them from controllers in Europe. And maybe that's the strategy, is go after that handful of big fish, and they will of necessity then contractually require partners and customers and vendors to do what they need to do.
Before you ask, can I just ask, is it Melissa who's running the slides? I can't remember who's running the slides. Do we have any questions in the chat? Are there any questions online that we can't see that we're ignoring here because we're in this room?
Good point. Sorry if we are.
Sorry, Mark. I didn't hear any response, but
And don't feel shy, just shout it out.
put them in the chat. Someone's looking at that, I hope.
I want to make a point though to Spencer's question. Yeah, it may not be a big risk for you, but there's a reflection of that risk that comes up in every investment deal and every M&A deal, because the buyer in the M&A or the investor wants to know that you're compliant with those things. So it's one thing for you to make a decision where we know we may not be completely compliant on this, but it's not a big risk and we're going to take it. But you don't get to choose whether the investor or the buyer of your company wants to take that, and it becomes another hurdle. It adds to the difficulty in those other transactions.
And Mark, you just stole a point that I was going to make, that
I'm like that.
okay, I'm sorry, but I have firsthand experience with this. You could be a small Utah company, you think you don't have jurisdictional problems, you think you're too small, and then you get a phone call from one of the big fish who wants to buy you, and you've never heard the initials GDPR in your entire life before, and all of a sudden it's a giant problem. And basically,
Stryker says, we were going to buy you, but not now.
And so Sam knows who I'm talking about. I mean, it became a very lengthy, expensive due diligence of numerous points to get through. It was probably the most difficult part of the entire due diligence process.
Oh, wow. That's
So yeah,
interesting feedback.
it's the big fish who are coming down on you and saying, you have to prove to us that you're compliant with all this. And they're like, we don't even know what you're talking about. So.
Yeah, and I'm on the privacy side of the diligence projects on deals, and I mean, we see that often. You ask about these privacy laws, and during a management call, they have no clue what it is, and they said, "Oh, well, we outsourced our cybersecurity." I'm like, "Well, I'm asking about data privacy. It's very different." And the people that they outsource it to, some of them just auto-generate certain privacy policies, which put in a bunch of disclosures that don't apply to them. I can't tell you how many diligence deals I've done where they just randomly throw in that they're subject to the California Privacy Act and
GDPR.
and China law. And then you ask them, well, do you have annual gross revenue of $25 million or more? They're like, nope. Do you collect this much volume of data? Nope. Do you target activities in Europe? Nope.
But we took this off the Meta site.
We changed, pasted this from something, and Yeah, and what ends up happening there is now you've represented to the public, you're subject to these laws, you're gonna honor these rights. And then when a request comes in for an access request or correction request, they just drop the ball. And then now you're subject to an investigation. Now you're engaging in an unfair and deceptive practices act under the Section 5 of the FTC Act. And so you don't want to do that. It's better not to say anything than to say too much and say it wrong.
And maybe just one last point to your point, Spencer, about the indirect impacts of the potential risk enforcement are your customers, right? Customers of the SaaS provider. They are the ones that are really making you worry about this, right? Because they want disclosed like warranties from you that you are compliant. What are you doing to be compliant?
I think just one more thing to your point as well. I mean, it touches on the point that Colin raised. With the EU or the EEA, you're dealing with a union, so you're dealing with a number of different data protection authorities potentially. So it's very difficult to say, you know, France is really hot on this, but Germany's a little less cool on that, you know. And if you've got that global presence or you do touch all those jurisdictions, you need to be thinking about, might not have the risk here, but actually I might have the risk over here. I mean, the UK, for instance, has not been very hot when it comes to fines. Instead, there's a bit more of a dialogue that happens if an incident, you know. I mean, we've worked on a number of incidents from a data breach perspective, and it's quite a nice, you know, process in some jurisdictions and not in others. So to your question, yes, I think that the better decision is beginning of the barking, but really this is just how it's enforced. It's a jurisdiction by jurisdiction basis in the EU. It's not uniform.
Jumping in with one question from the chat as we're almost at time. Somebody's asked, what if we are already certified under the older data privacy framework? Do we need to continue as an SaaS provider?
Yeah, I mean, if you're certified under Privacy Shield, you automatically roll over into the data privacy framework. Of course, you need to update your privacy policy to reflect that you're certified under data privacy framework instead of the invalidated Privacy Shield. Whether you need to stay certified, you don't. I mean, you could revoke your certification and withdraw. But if you're already certified, I mean, you can do the belt and suspenders approach and just stay certified and sign the SECs as well. The one benefit of doing it that way is you don't need to do transfer impact assessments because you're already certified. And by having that backup SEC signed up, if the data privacy framework gets invalidated, then at least you have a backup plan. You already signed SECs as the basis for sending the data across borders. Also, I should say under data privacy framework, you do need to enter into a contract with the recipient of the data regardless. That has at least some basic terms, but of course, by signing the SECs, you covered that and many more.
And I think just to Arsenal's point, you know, one clause that you'd expect to see is that you recertify every year because it is an annual process.
Yeah.
So if you have certified, you would expect your counterparties in Europe to request that type of provision be put in the arrangement.
So to one other point on that, John and I have looked into that a little bit, and you know, you do automatically roll over, but there's been some time that's passed between the old Privacy Shield and the data privacy framework. And when you go look at yourself, your company's data online, make sure it's not outdated because you know your privacy officer could have changed. In this one instance, our company name had changed, so you want to go make sure that that's up to date when you recertify. So it's a privacy policy. It's the information you're putting out there. So yes, it does roll over, but check to make sure that your information is accurate.
Absolutely, yeah. And you might have acquired certain companies, so now you have additional subsidiaries that are within the ambit. So yeah, a lot can change.
Right, any other questions? Well, thank you all very much.
One more from the chat. If you walk away from the Shield, you have obligations. Do you have obligations on how you deal with the data collected under Shield?
You said the first part of that question again, and we were clapping so loudly. Standing ovation was dying down when you started.
If you walk away from the shield, do you have obligations on how you deal with the data collected under shield?
Yeah, you do, because one of the requirements when you certify is you need to give a transparency notice. You need to represent to your data subjects or consumers to whom you're making the representations about your privacy practices that you agree to abide by certain principles. And then if you gave that notice and a person relied on that notice to give their personal information to your company, you need to treat that personal information within the context and within the purview of what you told the consumer you would do. So those obligations remain. And if you renege on it, then now you've lied to your consumers by saying you would do something, but then you're saying now you're not going to do it.
Including the obligation to delete the data when you don't need it anymore.
Yeah.
Right. Well, thanks again very much.
One more applause.